Oh, shut up, Mr. Monkey. God damn it. I didn't realize I wasn't muted. Okay. So you two was just glitching. You're glitching. Faceta, you're the nut. You're the one who's the nut. You're nutty. Alright. Cookies? Fucking cookies? Maybe, I don't know. Oh, okay, we can do this.
The other day I was going to my local Starbucks, and when I got to the till, the barista not only had the audacity to be a woman, derogatory, but also talked to me. This is unacceptable. So in no uncertain terms, I screamed, "Excuse me, whore! I'm married! Do not flirt with me!" As I proceeded to show her my phone wallpaper and wallet photos, which were both of my lifelong shadow, and then I proceeded to growl at her until the police arrived to escort me out. So how was you guys' days?
Like, I feel like she's my younger sister.
She's
I'm
like,
like,
one.
what did you do?
Rise,
What did you do?
I'm in an anime!
I'm in an anime.
Whenever. But yeah, I'm probably gonna end early here because I'm feeling a little bit sick at the moment.
I'm so
I've
sorry.
been a little sick.
Oh
so
no, she's
I
like
picked
talking
my
about how
nose
she's
again,
sick.
so-
She's talking about how sick she is.
Keep your mouth open. I'm almost done.
Whenever, call you Waggy.
God, man.
Wait, I still locked her? Oh no! Wait, she's gonna ban me! Just ban me, just do it, just ban me, don't even talk! Just ban me! Just ban me, just ban me, just ban me, just stop letting me suffer! She ended stream!
We could do rock, paper, scissors instead if tug of war is too complicated for you.
Rock, paper, scissors.
Alright, on go.
Wait.
Go.
Okay.
Rock.
Paper.
Let's do best of 3. That was just the warm-up.
Okay.
Rock.
Paper.
Paper.
Scissors?
Beetle, I'm going to need some help.
I can't help you. There's nothing I can do here. I don't think this is the best choice of game.
You got anyone you want to call out in the heavyweight division?
Oh, you know it, lad. You know that Hassan Piker? I'm coming to kill you! In Los Angeles, at your house!
Or in the ring?
No, in real life. I'm going to stalk him and become obsessed with him. And wear his makeup and his dresses. And use his skin as a coat. Like the ancient Irish did.
Well, that's your winner, Sam! Hey!
Bloody.
You heard it here, folks. Hello, everybody. How are we doing? This fine, fabulous, fantastic, I believe it's a Tuesday. I think it's a Tuesday. I don't know. Again, I'm underground. I'm hiding. Santa has intensified his search for me. But again, they haven't breached my perimeter. My airspace is good. I only need to last another week. You know, a little over a week, and I should be good. I can tell out of the bunker. So, you know, that's nice. Hello to my chatters, the Steva GP, Ravenfire, Nauru, Hime, This Fantasy, Magma Fox, R13, Cerebrals, Cerberus, Potion Maximus. I hope you all are doing well. We have a number of Lawtube and Lawtube-esque things to be reacting today, including stuff from Nate the Lawyer, Attorney Larry Foreman, Attorney Tom, and of course our favorite legal mindset. So we have those, as well as a I think it's like a Midwest crime, like a DUI, like body cam footage thing, and then we have another relatively short little court interaction. Magma Fox, thank you for being a Earl for 10 months. Hoi hoi, holy moly, nearly a year. Yeah, very close. Magic Misa, how's it going? I'm an elf, but Santa says my chest is too big to be seen in the vicinity of children. So he gave me paid leave. John Wolf, how's it going? Mr. Monkey, Bissy Boo, how's it going? Hey, Eva, Santa asked where you lived, and I assumed it was fine telling him. Look, it's you can tell him that if you want, but I am currently at a bunker in an undisclosed location, okay? Santa's not gonna find me, and I will remain in this bunker, again, at an undisclosed location, until the new year, until I know he's called off his forces, okay? Francis Karma, a YT, or VT, wait a minute. You said no notification. Uh-oh. Okay, Alade, it's time to flap. It literally notified Discord. I notified on Twitter. I guess the other thing didn't work, right? The YouTube notification. I guess that's what you're talking about. But that's alright, that's alright. We're going to start. We're gonna start right out the gate with a goalie. Posted, again, 3 days ago. I have no idea how the fuck he just came out of a freaking, like, literally weeks ago. This guy came out of a freaking, out of a surgery for his brain, and he's still just he's doing content. That's amazing. Anyway, let us go ahead and get my stream deck over here, actually. Hey. No, don't do that. There we go. Alright, there we go. Background music off. Let's go ahead and also do this. Get it all set up so we can watch. Bada bing, bada boom, zoom. Let me tell you what. Alright, let's do it. I didn't see the Discord notification. I've turned off the bell, so hopefully... Turned on the bell, so hopefully I'll get the notification. Yeah, no worries.
A judge in Wisconsin has been arrested and charged for allegedly obstructing ICE agents. Judge Hannah Dugan is accused of helping an undocumented immigrant avoid arrest.
Well, today, a whole new level. Today, the FBI arrested a county judge.
Hold on, I'm sorry. Okay, jury convicts sitting judge of felony for helping violent abuser flee ICE. Okay, whoa, that's quite... Gosh darn. I mean, that's what you fuck around, you find out, even if you're a judge.
In Milwaukee,
Let's
Wisconsin.
See what's going on.
According to the FBI, this judge knew that Trump's immigration agents were outside her courtroom waiting to arrest a man who was before her court. They say she sent the immigration agents away from her hearing room and then escorted the man and his lawyer out of the courtroom through a private exit.
Hi, good morning, Jackie.
Oh, yeah, you absolutely, that's obstruction. That's, yeah, you're interfering with, okay, what are you doing? Look, judges aren't above the law. You know, I don't know why they thought they would be able to get away with this. This one felt pretty quick. Yeah, because it's pretty cut and dry, I think.
Video shows the escape with the black-robed judge sworn to uphold the law, instead breaking it.
Now let's get to that verdict. On the felony count, the jury decided Dugan is guilty of obstructing a federal agency.
Yeah. Yeah, I mean, that's a valid charge.
Here's a quick message from the sponsor of this video, ZocDoc. You ever do anything where something's off? Your eye's swollen, your neck got a weird pain, or you have a cold that just won't quit. And instead of calling a doctor, you scroll TikTok and YouTube like that's gonna fix it. Or maybe you're just too busy. You think it'll heal on its own. Or you're like, I don't know which doctor to go to. Trust me, I've made every excuse in the book too. But now I use ZocDoc, and it makes things a lot easier. ZocDoc is a free app and website where you can search and compare high quality in-network doctors and instantly book appointments. We're talking about over 100,000 doctors from across every specialty.
Damn.
From mental health, dental, primary care, urgent care, you name it, they got it. And with ZocDoc, you can filter by insurance, see who's nearby, and check real reviews from verified patients. Now, simply just pick your time slot and boom, appointments usually happen between 24 and 72 hours, sometimes even the same day. Now, full disclosure, I personally use ZocDoc, and the doctor that I go to now, I found on ZocDoc. Stop putting off those doctor's appointments. Go to ZocDoc.com/Nate the Lawyer. The link is in the pinned comment or in the description of this video. Now, back to the story. So first, let's start in Milwaukee, where Judge Hannah Dugan seems to be in trouble with the feds for trying to help an illegal immigrant.
Hannah Dugan. Oh, Dugan of the Hannah. Okay, I'm sorry. Okay, this is very serious.
Evade ICE. Now, to really understand this story, I think you need to understand why this guy was there in the first place. Here is Pam Bondi, Attorney General of the United States. She's going to explain it.
It was appalling to all of us what happened. I used to be a domestic violence prosecutor, and this case involved someone who was deported under President Obama, came back into our country, we don't know when, illegally, and he was living in a residence, and he beat up a man so badly he had to go to the hospital, his roommate. He punched him with a closed fist in the face 30 times. The victim fell to the ground and he choked him. Then the girlfriend came in, tried to break it up. He punched a woman in the face with a closed fist so hard she fell to the ground. He hit her in the arm. Both of them had to go to the hospital. The fight's broken up. They're taken to the hospital, and he's threatening to do further harm to them later. So she's a sitting judge on a domestic violence case. He's the defendant, Ruiz, 2 victims and a prosecutor, a state prosecutor in the courtroom. It is routinely done when people are picked up on any kind of warrants that it's done outside a courtroom. It's been done in that courthouse. It's been done in a courthouse where I prosecuted 20 years ago. The reason? Because you know, executing a warrant is one of the most dangerous things law enforcement officers can do. You never know what you're going to encounter behind that door, what kind of weapons, with any defendant. So the safest place to do it is if you know they're going to be in a courthouse because they've gone through security.
Now, I want to let you listen to MSNBC and how they're describing what happened. Listen to Rachel Maddow.
If Trump's immigration agents are staking out courthouses to grab people, to kidnap people.
I just want to be clear, no one was kidnapped. He was arrested. He's not been kidnapped.
Yeah, no, this guy,
and the second thing I want to mention is that she's not going to mention the victims, but she's saying him being arrested for his immigration issues is kidnapping. But let her continue.
Once they show up to take part in a lawful court proceeding, that stops judges from fulfilling their responsibilities under the law for what happens with their cases and in their courtrooms. Now, this was also a point of tension in Trump's first term. In Trump's first term, he also sent immigration agents to go to try to arrest people at their court appearances. And it was a flashpoint then. State judges have a duty to ensure the safety of the people who appear before them in court, whether as plaintiffs or defendants or witnesses. Well, today, a whole new level. Today, the FBI arrested a county judge in Milwaukee, Wisconsin. According to the FBI, this judge knew that Trump's immigration agents were outside her courtroom waiting to arrest a man who was before her court. They say she sent the immigration agents away from her hearing room and then escorted the man and his lawyer out of the courtroom through a private exit. For that, the Trump administration has arrested her and charged her with 2 felonies.
So as you see, Rachel Maddow didn't bring up the fact that he's here illegally. She didn't bring up the fact that he's in court on a domestic violence beef.
Yeah, she let out a lot of relevant information in regards to this man, his case, and what happened.
because he's punched someone 30 times, as it says here. Now, you have to love the way Rachel Maddow spun this case. She's trying to make the argument that by helping this guy, this domestic batterer, evade ICE agents, that was in some way protecting him from being kidnapped. Talk about a stretch. Now, I know my fans and you guys don't like to hear the spin. You want to see the videotape. So let's go to the videotape. So the courthouse released the surveillance tape to show us exactly what happened this day in this particular courthouse in Milwaukee. All right, so first things first, this is the suspect, Eduardo Flores Ruiz. And he has a court hearing today based on the information you heard earlier of him punching somebody 30 times and beating up his girlfriend. He's been arrested and is being prosecuted by the good people in Milwaukee. Now, when ICE becomes aware of his arrest and detainment, they go to Milwaukee to go pick him up because he happens to be in the country illegally. So on April 18th at 8:16 a.m., federal officers went to the courthouse in Milwaukee. The first two officers positioned themselves outside of the courtroom, and they were later met by two other officers who were serving in a backup role. Now at 8:39 a.m., Ruiz comes to the courthouse and clears the metal detectors. So now law enforcement knows he doesn't have any weapons, and it's going to be easy to take him because they have multiple officers. Now at exactly 8:40, 1 minute later, you see Judge Dugan on the camera headed into her courtroom. Now, at exactly 3 minutes after the judge gets there, she puts on her robe and runs outside and tells the ICE officers to go to the chief judge's office. And then the judge sends the three other agents who are down the hall also to the chief judge's office. Now, after the ICE agents went to speak to the chief judge, Dugan pulled a whole bunch of tricks. First, she postponed Ruiz's hearing about the whole beating the guy up and beating up his ex-girlfriend and instructed him to leave through a non-public entrance so he could avoid ICE agents. So while the agents are talking to the chief judge, Ruiz is slipping out the back door. You're looking at the actual footage for those of you who have any questions. Now, I have to pause it right here for 1 second because you see this guy right here? Well, he's a federal agent, and he just stood by the courtroom just in case some funny business happened. And now Ruiz is walking past him about to leave the courthouse. And what does he do? Well, he follows Ruiz. Now, Ruiz leaves the building, but ICE agents are outside, and he is arrested. So the FBI and the Department of Justice looked at the video we just saw and said, hey, this judge has committed a crime, and we're going to arrest him. Here is NBC explaining.
Federal authorities reportedly arrested a Milwaukee County Circuit judge this morning for allegedly assisting an undocumented migrant. In a since-deleted tweet from FBI Director Kash Patel, he said this judge was arrested on charges of obstruction related to an immigration arrest.
That's right. So Judge Hannah Dugan is the person who's been arrested here, facing 2 counts. The court paperwork was just unsealed: obstructing or impeding a proceeding before a department or agency of the United States and concealing an individual to prevent his discovery and arrest, at least according to the information that the federal prosecutors and the FBI has alleged here in the course of their investigation. She moved this individual, who's wanted by ICE, for which there was an active and a arrest warrant for, to be removed from the United States, moved him through the jury door, allowing him to effectively evade ICE agents. This individual was facing criminal charges, 3 misdemeanor counts related to physical assault, and so that's why they were in the courthouse in the first place.
I would say that NBC here is doing a pretty decent job of reporting the facts as they are. The other news agency, though, what was it? I forgot what the other one was, but the other one that was pretty bad. The one with Rachel Maddow on it. That was really bad.
The grand jury indicted the judge on those 2 counts, and then the judge pleaded not guilty to those charges, but said she was immune from prosecution because she was acting in an official capacity as a judge.
A Wisconsin judge has pleaded not guilty to federal charges related to her allegedly helping a man evade immigration authorities. Hannah Dugan was indicted this week on charges of obstruction and concealing an individual to prevent arrest. Dugan's attorneys are moving to have the case dismissed, arguing her actions were in her official capacity as a judge and that she has immunity from criminal prosecution, citing that 2024 Supreme Court decision in President Trump's favor.
So now, to make a long story short, the judge's motion was denied. She did not have immunity like the president of the United States because she wasn't the president. She's just the judge. So she went to trial, and the jury didn't buy the whole, hey, I'm a judge and I can do whatever I want. They convicted her on the felony count. But they did acquit her on a misdemeanor, which is kind of not really great for the judge because you'd rather be convicted of the misdemeanor and not the felony, but they convicted her of the felony.
Yeah, kind of weird. It went the other way
Good
around.
evening. Welcome into our CBS 58 studios, and we start tonight with breaking news on the verdict in the trial of Judge Hannah Dugan.
Judge Dugan was accused of trying to hide an undocumented immigrant from immigrations and customs enforcement agents in the Milwaukee courthouse.
Yeah, that happened in April of this year, bringing national attention to Milwaukee amidst heightened tensions over immigration enforcement in the United States. It spurred questions over whether immigration enforcement agents should be able to arrest people in courthouses.
Now let's get to that verdict. On the felony count, the jury decided Dugan is guilty of obstructing a federal agency. On count 2, a misdemeanor, the jury decided the judge is not guilty of concealing someone to prevent arrest.
So this judge got convicted of the felony. So if you think about it, that is like the worst case scenario because she has a law license that now is probably going to be suspended because she's a convicted felon. Then you also have something like her judgeship. You know, how many convicted felons can be judges?
Ashley, who testified in the Dugan trial, would not say whether he would ask for Dugan's resignation. In an emailed statement from a spokesperson, Ashley said it would be inappropriate for me to comment. Judge Dugan remains prohibited from exercising the powers of a circuit court judge under an existing order of the Wisconsin Supreme Court, which remains in effect.
And what about things like your rights to vote and your right to carry firearms? She's lost all of that. So this judge has some real issues on her hands when it comes to this particular issue because she is a convicted felon when she gets sentenced. And this case vindicates me a little bit because, mind you guys, I was just suffering with a brain tumor, right? When this case first came across my desk, I'm like, oh, she's obviously going to be convicted. And all my liberal friends, no, she's not going to get convicted. No, Nate, you don't know what you're talking about. But guess what? She was convicted because the evidence was overwhelming. And all those liberal attorneys that I know, they didn't have brain tumors. So I don't think they have that excuse. But let me know what you feel about this particular verdict in the comments section. I think there's no other option because she did what they alleged she did. If you believe helping someone evade
situation. That's a very cut and dry situation. I'm sorry, she's guilty of. I mean, she's on camera. She's literally on camera. What more do you want? So while oh no, why be upset, that this judge got arrested. The fact is, at least in this country, nobody is supposed to be above the law. That being said, we're going to go ahead and move right on along to Attorney Larry Foreman with the following video titled, My Client Refused a Blood Test, Now We Are on Trial for His Life. Not sure what's going on. I'm sure Larry Foreman here will tell us, though.
You must follow the law. The law says... Glorious. Is it a lawsuit? Probably. Why not? Well, hello, everybody, and welcome back to Buckle Up. It's the Law with Attorney Larry Foreman. Folks, I am so excited. Today, I am going to share with you all my own jury trial that happened just last month in November of 2025. This is a jury trial that I have tried in Hardin County, Kentucky, in Elizabethtown on November 5th, 2025. My client was charged with 6 charges: reckless driving, which carries just a fine up to $200. Failure to maintain insurance, which carries up to, believe it or not, 90 days in jail and a $1,000 fine. Failure to wear a seatbelt, maximum $100 in fine. Failure to notify Department of Transportation of an address change, which is another maximum $100 fine. Operating a motor vehicle under the influence,
Okay. Just real quick, though.
maximum.
Failure to notify Department of Transportation of an address change. While this is technically a violation, this also is kind of telling me they're trying to hit him with everything. I mean, literally everything. Are you kidding me with this?
Which is another maximum $100 fine. Operating a motor vehicle under the influence, maximum $500 fine, and maximum 30 days in jail. And most interestingly, he was also charged with obstructing government operations. As you will see, he was asked to submit to a blood draw, and he said no. And so the police officer went and got a warrant from a judge over the phone at 3 o'clock in the morning. And the judge electronically signed it, and still my client refused to submit to the blood draw. So he was charged with obstructing the operations of the police officer in his failure to comply with the request to submit to a blood draw. Now that one, folks, carries up to 1 year in jail and up to a $500 fine because it is a Class A misdemeanor in the Commonwealth of Kentucky. So the maximum penalty for that was 365 days. So the stakes were very, very high. Here are the facts. Trooper Grant with Kentucky State Police Post 4 pulls over my client, and this is what he writes. I observed the above vehicle while at the 5-star gas station in Vine Grove.
Hold on, real quick. And I'm not speaking to this particular case, right? But I do know that, and I think it was in Kentucky that this was happening, but I kept seeing these stories about, or was it Florida? Maybe Florida, Georgia, or Kentucky. But I kept getting these stories about these large swaths of DUI arrests and stuff like that, where the person blew zero on the breathalyzer. Where quite literally, there was no real evidence to suggest that there was actually under the influence driving happening, and yet the state actually proceeded with the prosecution regardless of a lack of evidence. I'm not sure if this is, in the same area that this was happening, but I do remember, reading this story about that.
The vehicle braked as it was going to enter the gas station at the front entrance near where I was in my marked state police cruiser, and then went around the back of the gas station. It then entered the gas station from the back entrance and pulled halfway into a parking space. The trooper continues, I then pulled around the gas station behind the vehicle to exit the gas station. At this time, while I was behind the vehicle then pulled fully into the parking space. A National Crime Information Center check advised me that the vehicle had no insurance. As I pulled out onto the 313, I observed the operator of the vehicle standing outside of his vehicle, watching me as I left. This behavior, based on my training and experience, is indicative of being evasive and criminal activity being afoot. It is worth noting that the police officer is white and my client is African American. I then observed, the trooper continues, the vehicle on 313. As soon as I got behind the vehicle, it then made a right-hand turn onto 1500 Rogersville Road. At this time, I observed the vehicle swerve across the center line into the oncoming lane and swerve back into its lane of travel.
Like after it completed the turn? Or are you saying that saying in turning, it swerved across a center lane, because it's turning, and then it, got into its lane of travel? Like, that's a weird phrasing.
Conducted a traffic stop at this time and made contact with the above operator at the passenger side window. I could immediately smell the distinct odor of alcoholic beverage coming from the vehicle. The trooper continues. I observed that the operator had no seatbelt on and had red bloodshot eyes. He produced a Florida driver's license for identification and later stated that he lived in Louisville for over a year. The operator was initially uncooperative when I asked him to step out of the vehicle. The operator eventually complied to step out of the vehicle, and as I spoke to him, I could smell the distinct odor of alcoholic beverage coming from his person. The above was slurring his words and was evasive to questioning. The operator refused to conduct standardized field sobriety tests and stated he had last drank alcohol approximately 7 hours prior. The operator was then detained and read his Miranda rights. He stated he understood his rights. Based on the totality of the circumstances, the operator was placed under arrest for a DUI, driving under the influence. I then transported the operator to the Hardin County Detention Center where I read implied consent to him. He accepted his opportunity to contact an attorney. I had jail staff look up attorney phone numbers for him so he could call from the jail phone. Once the above stated, he was finished with the opportunity to contact an attorney. He refused a blood draw. I then presented the above with a signed search warrant for a blood sample signed by Judge Shoemate. She's one of the judges, one of the 2 judges in district court. We have Judge Shaw and Judge Shoemate. This case was in front of the other judge, Judge Shaw, as you will see in the video. The operator then refused the search warrant. His vehicle was towed by Merciful Towing, and body-worn camera and motor vehicle recording were operational at the time of the arrest. That is the entirety of the police officer's written notes in the citation, in the uniform citation,
what's the differences,
where
then?
he charged and arrested my client for the 6 charges that I just told you about. Over the next few videos, you will see the trial in its entirety, from pretrial motions, jury selection, opening statements, the direct and cross-examination of the police officer, closing arguments, and verdict. Let's begin.
I didn't realize it, but I guess we're in for a, series.
with pretrial motions. Enjoy, folks. And let me know what you think in the comments below after you like this video, comment below, and subscribe to the channel if you're not subscribed.
Which, by the way, you should be doing that. Oh, look at that. That's a perfect wink. That's a perfect wink. Like it. Notification bell. Oh, I already have it on. Oh, whatever.
Ready.
By complete accident last night, just doing my cursory research at the last minute just to see if there's anything that I may have missed. And it looks like this is a case of first impression for counsel. We've never had a trial with a warrant refusal. And in reading that case, and I can read the passage specifically related to the matter at hand, Your Honor, it seems to me that much like McCarthy, in McCarthy, as I'm sure you're aware, refusals to submit to a blood draw are inadmissible. But it doesn't mention anything about warrants. That's a 2019 case, an unpublished case. But Story, a published case, essentially, it doesn't say anything new. It simply says, in so many words, well, hold on, everybody. Remember what we said in 1998 in Combs v. Commonwealth, that you have to have serious physical injury or death? That hasn't changed. If you do not have serious physical injury or death, you cannot apply for a warrant. The warrant becomes invalid de facto.
Well, now what was the year
interesting.
on
2024.
December of 2024, Your Honor.
Okay. Okay.
Yes. And the specific language, just for, again, for purposes of the record, because I do believe if it does come in, it may be reversible error, and I just wanted to make sure the court is aware. Because the present case did not involve death or physical injury, the warrant was plainly prohibited by Kentucky Revised Statute 189A.1052B. That is the Kentucky Supreme Court writing in December 19th, 2024 in Story. Indeed, the warrant was also obtained more than 20 years after our explanation in Combs. It references Combs, that the statute was effectively a directive by the General Assembly to, quote, all executive branch employees, including police, not to seek a search warrant.
I think he's well, here's the thing. He's contesting the search warrant with, like, established case law, and, excuse me. That it sounds like it's coming from Kentucky Supreme Court. So really, I think he's got a very strong argument here. I mean, it's not that it's not an issue that he refused the blood test as a part of that search warrant. It's the fact that he was not near death or grave injury, or meaning he didn't meet any of the standards necessary for him to actually, have to accept that search warrant. That search warrant was invalid.
Or death does not result from a drunk driving offense. Thus, because the warrant was not merely technically deficient, And because the Commonwealth could not have acted with objective reasonableness in relying on it, the good faith exception does not apply, and accordingly, the Commonwealth may not justify its testing of Story's blood on the basis of the invalid search warrant. So to me, it seems like unless the court is all but clear, it's unambiguous, if there's no serious physical injury or death, and the government, the police, and in this case Trooper Grant, moved for a search warrant to search
it's not appropriate.
Person to obtain his blood, his refusal to do so was absolutely within the bounds of the law, and his refusal, much like McCarthy, now Story reaffirms warrants, is not admissible.
Great, Lauren.
Okay, and I'm not aware of that case, and that is such another seismic shift. I can't believe that I am not.
Your Honor, may the Commonwealth respond?
Yes, of course.
And may I grab my laptop to show you the statute?
Yes.
Have you been injured in an accident? Have you been hurt by a doctor? Have
Oh
you
my
suffered
God,
from a
amazing.
dog bite? Have you lost a loved one due to someone else's negligence? Call us, 1-844-774-HURT. Get a trial lawyer to get you the most money
Get
you
one.
deserve.
Chat. Do you understand? You gotta chat. You gotta chat. Look, if you have been injured, call Larry Foreman. Yeah. Where am I? Oh, there I am. If you need the Texas hammer. Oh, God, it's great. Okay, here we go.
Your Honor, the Commonwealth would actually agree with Mr. Foreman that the Supreme Court and what he wrote was applicable. However, that case was based off fact of a 2020 factual precedent. And so they were relying on the amended statute as of 2019. Now, Mr. Foreman's correct. They did amend it in 2021, but they did amend it again 2 years later in 2023. So we would agree in 2019 it was the legislative directive to limit or restrict search warrants, but as of today, 189A 105-2B has the legislature, and I can give you the statute.
Halifax, Halifax, it says, last time I was in Texas, I got a Texas Hammer commercial on TV. I really thought it was this. No, here's the thing. Like, because I've had to do a lot more traveling, like overland and like staying in hotels and stuff, this year than most years, I've been around. Because up until recently, I lived on a sailboat and I sailed everywhere I traveled. So, I didn't have hotel rooms and commercials. But like, holy shit, guys. Pretty much every state has every other commercial. It's either prescription commercials or it's a commercial for a personal injury and attorney. Like, those are pretty much the two main commercials I saw.
If you like, Your Honor, to allow a court of competent jurisdiction to get a search warrant.
I figured it had to be something like that. I mean, because we obviously there's been so much case law writing legislation about all of this since McCarthy, which threw a bomb into everything in terms of blood draws and DUI prosecutions. That's what I assumed there had to be something like that. So I'm sure you're absolutely correctly quoting them, but they were basing their decision on the prior statute as enacted before any amendments. Is that correct, or is there?
I don't think that's correct, Your Honor. And I could be wrong, but again, it seems to me that the language is unambiguous. They're not even specifying. They're not talking about they are mentioning the statute, but they are specifically alluding to, and again, I just want to read that portion of it, Your Honor.
No, it's okay. I heard that, but yeah,
our explanation in Combs was that they called back the 1998 case saying that nothing has changed in the last 26, at the time, now 27 years. So again, Your Honor, your decision.
Yeah, no, that makes okay. No, I get it. No, okay, yeah, no. They're not just responding to the case, unambiguously. They're literally saying, hey, in the 26 years since we last addressed this, back all the way in 1980s, right? Or however long it was. In however long we have, nothing has actually changed in regards to, in order to have a search warrant be valid for a blood draw, the person needs to be gravely injured or, in another similar condition. He's doing a good job. And I'm a little worried because the judge is kind of like, no, yeah, the prosecution's making a lot of sense. I'm like, I'm not really sure how that's possible because he's just reading off the fucking
decision
the
may be. I'm
statute.
simply
What the
stating
hell?
that I fear and I believe, just for purposes of the record, and I want to make the record clear and make my objection noted, that I don't believe, I think based on the story of the Commonwealth, unless there is death or serious physical injury, because that's been the law since 1998 in Combs v. Commonwealth.
Yeah.
And I'll give you a second.
1998.
Yeah, I mean, I'll let you respond in a second, Gavin. Excuse me. Since Combs v. Commonwealth was explicitly clear, unambiguous, once again, that unless there's death or serious physical injury, a blood draw may not be extracted by force. So,
Which didn't happen here.
which didn't happen here, but the warrant essentially kind of forces the individual to give their blood whether they like it or not. And stories.
Oh, good fucking argument. Good fucking argument. Because, yeah, a warrant would absolutely force your hand. And in order, like, if he were to comply with that, he is, in a sense, being forced, you know, that it's a forced blood draw at that point. No, I understand the argument. I like it.
Says no. Unless there's death or serious physical injury, you can't even apply for a warrant. But that's my...
Okay.
Your Honor.
And your brief response, and then we'll get started.
The Commonwealth would disagree with Mr. Foreman's ontological meaning of the statute. It doesn't.
All right, buddy. With the fucking ontological. Yeah, 5-syllable words. Simmer down.
Force you to give your blood. It just says if you don't give your blood, there's going to be a consequence. They do not hold him down as you stated in this case. First, and then actually in this case, but Justice Bissage, says at all times relevant to this case. It was 2020. Well,
hold on. Okay, first of all, while that was kind of like a side thing about, about that kind of an argument, the argument really is the application for the warrant, period, was invalid, thus making the warrant invalid for even asking because, again, he was not gravely injured or dead.
2025 in the statute is 2023 as amended.
Yeah, and McCarthy did a number on all of us and certainly threw a lot of confusion into this, but I believe that that's, as of now, as of the amendment of the statute, that it was appropriate to ask for the search warrant. If it's denied, there are consequences. There are other jurisdictions that will, where the Commonwealth motion to hold a person in contempt who fails to abide by a lawful search warrant. I can appreciate that path. I mean, I don't like being, and it wasn't me in this situation, but I don't like being awakened in the middle of the night for a lawful search warrant and somebody doesn't abide by it, so. But no, well, thank you. Duly noted.
But that's the thing. It's not a lawful. That's the thing. The application for the search warrant isn't lawful in and of itself. That's what's being argued. Okay. Well, this isn't going our buddy Larry's way right now.
Appeal, and we will move forward.
And then, Your Honor, the Commonwealth actually has a brief, and I don't think you'll disagree. We have over 4 hours of video footage, and so we were just wondering, could we agree, we're going to, if we may, and of course the defense can bring up in cross or in their case in chief any portions that we do not play, but we're just skipping portions of the video, like driving with nobody in the back seat. I just wanted to get it on the record. I'm not trying to hide the ball or anything.
I'm in agreement. I'm not going to try and argue that the Commonwealth is playing hide and seek with the evidence. If there's anything that I need to play, I will fill in the jury with our portions of the video.
Now, can you, for the record, you brought up yesterday that you requested no statements about prior bad acts.
Yes, Your Honor.
Cool. I still have lemonade.
And I think the prosecution is not only aware, he's already indicated that he's muted the video during those portions. So we'll be on the lookout, but I imagine it's...
Now, full transparency, we sent it to our IT professional. He muted portions, but he did miss one. So my plan is to ask for a brief recess so I could remind Trooper Grant.
Okay, so Isaac says, So I looked it up, and I don't think ontological means what that guy thinks it means. Yeah, I was a little confused as well. So I'm not a sour elf. You're a sour elf. Is there an initiative or a petition I can sign for improved audio in U.S. courtroom? Dude, I fucking wish. Like, seriously, audio in courtrooms, it's pretty bad.
Hey, I'm just going to mute this bit and absolutely positively do not mention the prohibited items.
Okay, thank you.
And I'll ask if we're supposed to recess at the time.
Okay, that sounds like a good plan. All right.
Thank you, Judge.
Okay, thank you. Call them now. I'm going to step out, call those, do the jerk roll, and then let me know when we're done, and I'll step back out.
Are you looking at all six?
Alright, so what we doing?
I think we may have insurance on the car. His name's not on it, but the owner of the vehicle. So I'm going to try and get that to you before we get the jury seated.
Okay. So the car was insured, but he's not, like, listed as a driver on the insurance. Upgrade the audio, and there's still be boomer lawyers who don't use their mics. That's true. That's actually also true. When life gives you lemons, you do the lemon meme. I don't know what the lemon meme is.
It's a... Oh, here you go.
There's three. Of course they're going to do construction on it. They have a jury. They have ladders set up. No, that's fantastic.
Major construction or renovation.
Yeah.
As you can see, this is way up the
I mean, hey, some of those courthouses are like falling apart. You're joking? That's the funniest thing, and I'm not. You can send it to me. Or like send it in the Discord in the meme channel or something, but I'm not joking. I don't know what the lemon meme is. According to Google, ontological is of or relating to essence or the nature of being, and that was most generous of my results. The others have to do with ontology or the existence of God. What was he trying to say? That that's a weird one. Alright, so this is jury selection, it looks like. And they'll probably do voir dire. Well, that might be a different video. It's here. Yeah, we're getting close to being done, so I think it might be a different video. Do-do-do-do. Right, do-do-do. Earl Gaming, how's it going?
Okay, I'll let your name.
Why weren't you at elf practice? Alright, let's see what's going on. 10:30 in the morning. Who's that lady? Oh, she must be another. Isn't that a decent turnout for this little Kentucky courthouse? Wait, existence of God? Would that mean prosecution is making an argument for heresy? Always and forever. Hell no. Listening to this on a forklift and hearing a lot of smashing sound concerning. Yeah, that's fair. Yeah, I mean, look, I feel like I really feel like Larry should have won that. There, like the wording was very clear. I don't know. See, she's somebody she's also a judge who has found the McCarthy ruling pretty, like, messy, I guess. So I mean, she's not a fan in general of, I think any restrictions of the court being made in that regard. Come on, what are we doing?
I wanted to thank you all for watching. I hope you enjoyed it. I love every single one of you, and I will see you all in the continuation of this jury trial in the next video. Bye, everybody.
There you go. Okay. Very interesting, very interesting. This was posted 6 days ago. I will be sure to open up Larry Foreman's channel and keep an eye out for any updates regarding that trial. But yeah, that was pretty interesting. I don't know what there really is to say about this one. I try to appeal that. I feel like I'd have to know more about the law and how case laws be amended statutes. I mean, again, it's all up to the judge and how they interpret those laws. You know, the arguments are going to be made, but ultimately speaking, you know, and yeah, they could take it to appeal if they want, but ultimately speaking, the judge's interpretation of that law is going to determine, you know, what side of the argument they're going to stand on. Alright, so the next video that we have here is from Attorney Tom. It's been a hot minute since we've seen anything from him. Apparently he's in his antitrust era. But he says the reason Pepsi is so expensive. I didn't know that Pepsi was expensive. Apparently it is. I don't often buy soda. But I did look at prices, like, for soda, because of this video. And yeah, fucking soda prices are way more expensive than they were, like, I don't know, when I last drank a bunch of soda was like 6 years ago. Like, it has gone kind of crazy in terms of pricing for soda over the last, you know, I'd say decade. But here we go.
Why is Pepsi so expensive? What's going on, y'all? Attorney Tom here. I'm in my antitrust era, and it's a Sunday, and the air conditioning's not on in my office, and it's very hot. But I'm hot.
Again, look, it's fine. I don't drink soda. So, you know, it can be as expensive as it wants to be. I'm not gonna drink it. If I remember correctly, Pepsi is cheaper than Coca-Cola, but on average, all sodas are pricey now. Yes, that's true.
I'm hot because I'm mad. Somebody needs to get a knowledge hammer because of some shenanigans going on. Let's get into it. Why is Pepsi so expensive, allegedly? Behind me, you can see some data from the Fed on the price of soda over the past 7 or 8 years.
Look at that. That is ridiculous. What is this? US dollars per what liter? I don't understand. Oh, average cost for 12-pack. 12 ounce cans. Yeah, it was yeah. That's just kind of wild.
You can clearly see it's going up. The question is it going up because of inflation or because of maybe an illegal price-fixing conspiracy, allegedly? Before we continue, I want to give a shout-out to Stacy Mitchell.
Hold on. We had ourselves a concern.
Stacey Mitchell is the co-director at the Institute for Local Self-Reliance. I follow her on Twitter. This is totally because of her. She unsealed what we are about to look at, and she made a Twitter thread about it, which is how I learned about it. We're talking about a recently unsealed FTC complaint against PepsiCo. Who is PepsiCo? Of course, PepsiCo is one of the two major players in the soda market. It's them and Coke. Well, the FTC sued under the very common, I'm sure everybody knows it, Robinson-Patman Act of 1936.
Yes, the Robinson-Patman Act of 1936. Yeah, I'm totally aware of this. Yeah, Tom, you don't even need to explain it. I understand.
It's now for anybody who doesn't know what the RPA is, as if. It's a U.S. federal law designed to prevent large buyers from gaining an unfair advantage over smaller competitors by prohibiting discriminatory pricing, promotional allowances, and services from suppliers, ensuring resellers are on the same functional level to receive proportionately equal terms to foster fair competition. Now, the key word in that sentence to me is proportionately equal, right? Because Pepsi's a large CPG consumer product or consumer packaged good, and they sell to a lot of retailers, right? There's Walmart, which is the largest retailer in the country. Then there's smaller retailers that are still pretty big, such as regional chains, such as Food Lion and H-E-B. And then there's smaller mom and pop gas stations. Yeah, right?
Mobile gas stations.
I am not suggesting that PepsiCo needs to treat the mom and pop the same as Walmart. Obviously, Walmart is going to do a lot more volume, but it needs to be proportionately equal. And the FTC brought claims alleging that PepsiCo was not acting in a correct way. Effectively, the allegation was, and I say was because it's sad, I'll get to that at the end. The allegation was Pepsi and Walmart are in a price-fixing conspiracy, so Walmart always has the lowest Pepsi price. What does that mean? Well, let's read some of the complaint. Walmart's price gap is an important metric that is regularly discussed.
Yeah, I mean, for a long time. I mean, like, if you go down to Mexico, like, good luck getting a Pepsi in a restaurant. You're pretty much everything's Coca-Cola, right? But I've noticed up here more and more often people go, is Pepsi okay? Or is what do they call their version of Sprite? Pepsi's version of Sprite. I think back when I was drinking soda, it was Sierra Mist. It's called something else now. But that would be a very common thing. Like, I'd order a Sprite and they're like, oh, it's Sierra Mist, okay?
Within Pepsi. One Pepsi executive noted in an email that if monthly or quarterly retail price caps are out of balance, Walmart will pressure Pepsi for actions. Certain retailers are high on Pepsi's radar as stores that often self-fund promotions on Pepsi soft drinks to attract consumers in a way that can undermine Walmart's price cap.
Also,
in internal documents, Pepsi refers to these price cutters as offenders. Pepsi and Walmart monitor these retailers' price closely for signs their promotions are threatening the price gap.
Yeah, okay, so these are the allegations. I mean, what's the proof here? Obviously, that could have
advantage in the resale of Pepsi soft drinks that Pepsi has committed to Walmart to help it maintain. When Pepsi or Walmart sees sustained price cutting by these retailers, Pepsi attempts to reverse any leakage and restore Walmart's retail price gap. Let me put that in layman's terms. So, when Pepsi deals with retailers, they can primarily fight on two fronts. One is the rate at which they sell their product to the retailer. The other is how much money they can give the retailer for promos. If you've ever walked in a grocery store, you've walked down the aisle, you've seen an end cap with a big display of a product saying, hey, buy this product or whatever. That CPG likely is paying the retailer to have that end cap, to do a promotion, to promote their product. So when Pepsi negotiates with these retailers, they give them a rate, they give them a promo, okay? Of course, if you're Walmart and you sell the most volume, presumably you could get a lower rate and you could get more money in promo because you are Walmart. But what happens when a regional brand such as Food Lion says, okay, you're going to give me a higher rate, but I'm okay with accepting less margin. And also, you don't need to pay me to promo. I'm going to promo it myself because I want customers in the store, and customers are attracted to low prices.
That's
which
right,
brings
get
us
gifted.
back to the complaint. Pepsi similarly tracks to seek to correct for Walmart sales leakage to competing retailers resulting from low retail prices at those stores. As a Pepsi VP of
Gotcha,
sales
Francis.
testified, leakage means through customer panel data, we see percentage of consumers that are shifting outside of Walmart to another retailer.
Yes,
And where
where does the
Walmart is
doctor-
the least competitive, there's
Thank
the
you
greatest
so much
share
for the
of
vibe.
market lost. Now, Pepsi has...
So here's the thing. While Squirt is the like the Dr. Pepper brand, the issue is Squirt isn't just a lemon lime soda. It's a grapefruit soda. So it is intrinsically different than say Sierra Mist or Starry and Sprite. It's not quite the same soda. It's a grapefruit soda.
As a pricing council. That pricing council includes several Pepsi executives, including the Pepsi Senior Director of Sales for Walmart.
Thrill
The
Gaming,
pricing
welcome
council
to
is
membership.
an organization within Pepsi's responsible for aligning price strategy decisions across customer accounts. The purpose of the pricing council: create awareness of hedge erosions. This bullet point right here: discuss
Raise
decision tree.
non-Walmart.
1. Raise non-Walmart customers through Q1 to
Q1.
prevent price risk. 2. Manage hedge with Walmart rollbacks. Let me give you an
there's a
example.
lot of-
An example of Pepsi strategizing to raise prices for another retailer is in response to the erosion of Walmart's price gap involves the supermarket retailer Food Lion. Food Lion is a regional supermarket that operates about 1,000 stores in 10 states. In 2022, Pepsi believed that Food Lion had heavily indexed
used
its
to go to
prices
Food Lion.
against Walmart and Kroger retailers relative to the competitors. Pepsi characterized Food Lion as the worst offender on the price gap for beating Walmart in price. So let me be clear. Pepsi
See,
is
this
totally
is
fine
so bad.
selling their product to Food Lion, but they're not fine when Food Lion decides to act in a free market and lower
and
their
if the price is lower than what they want them to set them to compared to Walmart. This is a serious issue. And to show that they keep going back like, oh, with Walmart's price points and to keep Walmart happy and all this is straight up antitrust shit, guys.
their prices
Like,
so they can
big
attract
fucking
customers.
time.
As a result, Food Lion threatened Walmart's price gap. Pepsi created a plan to nudge Food Lion's retail prices on Pepsi products upward by reducing
What the fu-
promotional
are you
payments and
kidding me?
allowances to Food Lion and raising other costs for Food Lion. The plan
Wow.
advised that Pepsi must commit to raising rates on Food Lion faster than market by minimum
Redacted.
annually. The plan included a multi-year roadmap that recommended a combination of 1, reduction in promotional payments, 2, wholesale price hikes to Food Lion's dead net price, including all discounts, allowances, and charges. And here's actually an example of what they did over here. So we have
Look at
raised
you, look
rates
at you with
across
your-
core
Look, you've got like the design board going on, dude.
carbonated soft drink packages, or close the gap on 12 packs, reduce gap
Yeah.
on the promo market by 1 point, reduce holiday promotion weeks, raise promo dead net price to match market must-buy economics, and delay or add scale back on promoting multiple core packages in the same week. In the end, Pepsi implemented a plan incorporating a reduction in promotional payments and allowances for Food Lion
Absolute
that
dicks.
involved building to redacted dead net price appreciation at Food Lion to correct Food Lion's encroachment on Walmart's price gap. So you can see
That's
how
fucking ridiculous.
this isn't okay. In my opinion,
No,
this
it's not.
isn't
It's
okay.
not. It's really not,
one thing
yeah.
to, because it's a self-fulfilling prophecy, right? As Stacy put it in her tweet, why does Pepsi do this? why Walmart's promise is, keep us the king of our domain and we'll make you the king of yours. Walmart helps Pepsi dominate the drink market in exchange for Pepsi ensuring that Walmart dominates groceries. Now, it's a self-fulfilling prophecy. Any of the pro-monopoly people out there in the audience might say, hey, Tom, free market.
Do we, I'm just saying, do we have pro-monopoly people out there? Who out here is, you know what, I'm gonna ask. I'm gonna actually ask. Hold on, I am, gonna see here. New window. Live streaming. Bring this up, go to engage with my audience. Start a poll. Are you pro-monopoly? Yes, no? Only if I miss a guide. Alright, there you guys go. Enjoy the poll while we finish off this video. I swear to God, if a bunch of you put yes, I'm gonna hurt you.
Walmart deserves the lowest prices by any means necessary. That is just business. But look, it's a death spiral, because if Walmart already has the lowest prices and nobody can compete, and Pepsi punishes anybody who has lower prices than Walmart, then those people will go out of business because consumers want to get the best price, because that's a reasonable thing to assume. And then when everybody else goes out of business, Walmart and Pepsi keep raising the prices. So the concept is, just because somebody offers the lowest price doesn't mean that it is the lowest price that should exist, right? If Walmart is the only game in town, then whatever they set the price at is the lowest price because they are the only competitor. That is not right. Now, why was Stacy in a position to unseal this FTC complaint? Well, that's because the FTC unfortunately dismissed this lawsuit against Pepsi. We see here the Biden-Harris FTC rushed to authorize this case just 3 days before President Trump's inauguration in a nakedly political effort to commit this administration to pursuing little more than a hunch that Pepsi violated the law. FTC Chairman Andrew Ferguson. Okay, yeah, I'm sure the FTC is politically motivated. You don't file a lawsuit thinking it's going to be over in 3 days, right? This is a multi-year deal. It's just laughable. I mean,
anybody who's familiar with lawsuits knows that it's not, it's not going to be 3 days and this is over. No, this is a big fucking lawsuit, too. This would take years.
Commissioner Melissa Hoyek said the staff at the Federal Trade Commission, both economists and lawyers, are highly skilled professionals, or
welcome to the chat.
They were. And we as a commission should not have sent them into court to fight a losing battle. Today's dismissal allows our dedicated staff to focus on bringing enforcement actions where we have reason to believe the law has been violated, where they can do the best, protect American consumers. That's just I think it's a total farce. I mean, how can you say that it was a losing battle when you don't give it an honest effort? The former FTC, Lena Khan, they monitored this for years. They don't just bring actions, okay? They clearly did their research. If there are emails that say Walmart pressures Pepsi and they're worried about Walmart's price gap, it's so disheartening. We're in our antitrust era here. This is what makes me proud to be a lawyer. I'm not involved in this case. I wish I was. Maybe I'll find an angle to get into this saga somehow. But Walmart and PepsiCo are facing antitrust price-fixing cases by private lawyers now that the FTC document is unsealed and is not working. They're trying to represent people who bought Pepsi products not at Walmart for presumably inflated prices because, of course, Walmart went out of their way allegedly or Pepsi went out of their way allegedly to ensure that Walmart always had the cheapest price, even though other retailers were willing to sell for cheaper. Okay, that's what we're talking about today.
That's pretty wild.
Hammer of shame Hammer of shame on this FTC.
Hammer of shame on the FTC. I kind of agree. Okay, so we have that one done. We have this one done. All right, so we have 3 more videos. Wow, I totally wasn't wrong about that. Literally, like 3 out of 4 times there, but whatever. Allegedly, in Minecraft and Roblox. Yes, indeed. Okay, so we're gonna finish off our Lawtube React stream. We still have the body cam. The body cam and the court cam footage, but this is the last Lawtube thing we're reacting to. And it's from Legal Mindset, and this is the Rob Reiner murder case. This is the fast facts for that. It's about 8-9 minutes long. So let's see what is going on.
Nick Reiner is now the prime suspect and charged with 2 counts of first-degree murder, specifically using a deadly weapon or knife in the case of the murder of his parents, Rob and Michelle Reiner. We're getting that today on The Legal Mindset. We teach you to be your own judge. I'm Andrew Esquire, American attorney, and this is a fast facts video, the quick and dirty version of the latest in legal news. And of course, as always, we have a nice PowerPoint for you guys today. So in this case, which happened in California, Los Angeles, California, we of course have the famous director Rob Reiner, who died at 78, and his wife Michelle Reiner, who died at 68 due to multiple.
Real quick, before we get to the tragic part, I managed to literally stop it right before the tragic part. So. Let me bring it up. This is what the fuck? Okay, people. You wanted to know the meme. There's the meme right here. Yes, okay, so now that we've done the meme, let's get back to the seriousness of this tragedy.
Stabbings while they were in bed. So they were in bed and they were stabbed multiple times. The prime suspect is their son, Nick Reiner, age 32. He was struggling with substance abuse at the time, and the body was indeed found by their daughter, which is their youngest child here, Romy.
I believe, and I can actually bring it up here, and it's going to end up being relevant to this, to how they play this case. But if I remember correctly, let me bring it up. Here we go. Nick Reiner was given schizophrenia meds before Vera's death. Prescribed. Okay, so it's just mentioning he was prescribed schizophrenia medication. I'm assuming if it's specifically medication for schizophrenia, that's obviously what his diagnosis was, but I'm not seeing any official diagnosis. However, if he was diagnosed with schizophrenia, that's going to play into his defense, and they will probably do an evaluation on whether or not he's competent enough to stand trial. If he is deemed incompetent to stand trial, what will happen is he will become a ward of the state, and he will be put into a state home and attempted to be given treatment until he is considered to be competent again to stand trial. And then he actually has to stand trial. So, don't know what's going to happen with him, but right now, it looks quite literally the meme of the insanity defense that everyone in Legal Mindset chat knows so well. That might very well be a player.
You can see in this picture, in this kind of family portrait here of all of them together. Of course, Rob, famous for This Is Spinal Tap and When Harry Met Sally. Also a very, very vocal critic of Trump, extremely vocal critic of Trump. So what's the background here? So the Reiner's youngest son, daughter Romy, found the parents' bodies at their Brentwood home, having suffered multiple stab wounds, apparently in their sleep. The previous evening, Nick and Rob had attended a party at Conan O'Brien's house and had been visibly arguing. So this was a public argument. Many people saw this. We still don't know. We really need to know the context of that argument. What were they arguing about?
No, but
what
it was pretty
Was
bad.
it money? Was it drugs? What was going on? But one very important fact is that Nick had a substance abuse issue. So it's very important we talk about what substances. So specifically, the issue was with heroin and methamphetamine, and it appears his meth use was a little bit more recent. Meth can cause mood swings, irritability, paranoia, hallucinations, and episodes of sudden violent behavior. He went to rehab at least 18 times. So clearly, the rehab did not work. Clearly, the rehab was either soft or inefficient, or just something that was really ineffective to get him out of this pattern of substance abuse, which you can see just looking at him. Obviously, there's some clear signs, just on the facial signs there. So another part of this is that he was very critical of Trump. So let's tune in here and actually listen into what Trump had to say when he was questioned about talking about Rob Reiner, because he didn't have much sympathy for Rob Reiner. So let's play this clip.
Mr. President, a number of Republicans have denounced your statement on Truth Social after the murder of Rob Reiner. Do you stand by that post?
Well, I wasn't a fan of his at all. He was a deranged person as far as Trump is concerned. He said he knew it was false. In fact, it's the exact opposite, that I was a friend of Russia, controlled by Russia. It was the Russia hoax. He was one of the people behind it. I think he hurt himself in career-wise. He became like a deranged person, Trump derangement syndrome. So I was not a fan of Rob Reiner at all in any way, shape, or form. I thought he was very bad for our country. Yeah.
So there you go. You can see Trump saying he thinks he has Trump derangement syndrome. He thinks he's bad for the country. So not really expressing much remorse there. Of course, it's your own individual right, in my opinion, whether or not you express remorse for someone's death. You don't have to say anything, right? But of course, Trump was one of his hated enemies. It seems like there's not a lot of forgiveness there, and there's not a lot of grieving there.
He just referred to himself, but yeah, Trump tends to do that. Look, I'm just going to look my hopefully on this one. There were a lot of people who, people were calling for them to be fired, for them to lose their jobs. Some of the more extreme people were calling for obviously more violent things. But when Charlie Kirk was tragically killed, and some people, expressed remorse, but also expressed that, hey, I don't believe Charlie Kirk was a great person, blah, blah, blah. I'm sorry, the right fucking came down on that shit like the fucking hammer of Thor. And so when asked, as the President of the United States and the leader of the Republican Party and the right in general, when asked about, this is the first time Trump has done this, right? So Trump is going to be Trump. I kind of get that. But, because he did it with John McCain, I think. And he's done it with Rob Reiner now, obviously. But, right off the tail of Charlie Kirk, and for that to happen, and for anyone to go, oh, well, that's just, Trump can do that, but, if you guys do that about someone we like, we're going to demand that you be fired and canceled and stuff like that. I think that people need to just turn down the temperature in general. Understand that, yeah, people can, wish someone well. I believe even in that post that where he was critical of Rob Reiner, he did still say rest in peace, and he gave what little condolences he could, but he did still give condolences. I don't appreciate the apparent hypocrisy on the right regarding this situation, but I understand it's also not a one-for-one situation.
A lot of people took umbrage to that, but there was a lot of animus between those two parties, right? So going forward, okay, so Nick...
Man, to be honest, I just wish people had more decorum across the board. Ain't that the fucking truth? I think if anything you could come out of this, that would be the big one.
Has now been charged, right? So let's look at his actual charges. So Nick has been charged with 2 counts of first-degree murder, along with a special circumstance for multiple murders. So, obviously it was both the, father and mother, right? and the use of a deadly weapon and knife. This charge carries a potential sentence of life in prison without the possibility of parole or the death penalty. Now, prosecutors in Los Angeles County have not made a decision on whether to see the death penalty. My kind of assessment of that is they probably won't, but we'll see. Anything can happen. I'm willing
look. Even though technically California has the death penalty, it's very rarely sought. I mean, very rarely sought, and even something as egregious as this, especially with what's come to light regarding his alleged schizophrenia and stuff like that, I don't think the prosecution will actually go for the death penalty. I really don't. I mean, maybe I'm not saying he doesn't deserve the death penalty. He killed his fucking parents. I'm just saying I don't know if the Los Angeles prosecutors have the cojones to actually do that.
be surprised on that one. Generally, though, the prosecutors in Los Angeles County and for these types of crimes, for example, homicide crimes, do have a conviction rate of 85 to 95% because of the strong evidence requirements. If they're bringing that sort of charge, bringing first degree, they typically think they have enough to prove first degree. In this case, he was walking on the street. There was blood on him, right? It's, a lot of signs that point to him being at the argument the day before. So it seems like there's a very, very strong presumption of the evidence against Nick Reiner. Now, many cases do plead to lesser charges, second degree murder or manslaughter. But I think in this case, particularly because of the multiple murders and because of the status of Rob Reiner and because the publicity of this, it would, I think, be very questionable if they...
It's a death penalty. Hold on. Oh, I didn't mean to do that. If the death penalty is on the table, I would be using it as a prosecutor to get a plea deal. Oh, so what you're saying, Francis, is you would try to get a plea out of him and tell him if he doesn't plea out, then you're going to go, all the way, and you're going to actually go for a plea, charge of the death penalty. I mean, that's pretty good. If I were a blood-sucking prosecutor, that's fair. Let's see here. Hold on real quick. I have a couple messages. Just making sure it's nothing important. Okay, oh, Jesus. Okay, let's do this.
Accepted a early plea down to, for example, manslaughter, maybe second degree, but I highly doubt they're going to get this thing down to manslaughter just based on the grisly circumstances of just murdering them in their sleep with the knives. Now, there are some wrinkles to this. Okay, so in the first court appearance, it was December 17th. That was his first criminal hearing. That was yesterday. The only thing he said was yes, Your Honor, when asked if he understood speedy trial, right? So just, do you understand speedy trial? Yes, that's pretty much it. He was wearing a suicide prevention vest. So that often is used not just for suicide, but to restrain people. So it may be.
Yeah, for instance, Tyler Robinson, the Charlie Kirk killer, when he was brought in on his arraignment and his first court appearances, he was also wearing a suicide prevention and a self-harm prevention vest.
To restrain him and keep him from going kind of crazy. The next hearing is on January 7th. So we have that to look forward to in about 2-3 weeks. And this is a big one. So he is going to be represented by attorney Alan Jackson, who represented Harvey Weinstein. Now, the success rate for him, for Alan Jackson, is 96%. So he has a 96 win rate. He's one of California's top lawyers. So when I went back and said, okay, I was a little kind of teasing you guys there. Okay, the average win rate is 85 to 95%. But they don't have Alan Jackson, right? So Alan Jackson's very good, right? He's got a high win rate. He's one of California's top lawyers. So what could we anticipate if we're looking at a defense here, right? And here's Alan Jackson, right? And here's obviously Nick. What is the judgment?
Here we go. Let's hear. At the present circumstance, I indicated that Nick Reiner is the perpetrator of the crime. However, Alan Jackson is acquitted of defensive turn of the insanity or dementia. Yeah, I'm fairly certain we're going to see an insanity plea.
So at present, the circumstances highly indicate that Nick Reiner is the perpetrator of the crime. But Alan Jackson is a very creative defense attorney. This could end up being, and I'm kind of calling this now, this could be our like OJ type case of the 2025, 2026, 2027
oh my
era,
God,
right?
he's kind of
This
right.
is something that's going to go on. It's going to take some time for this to get to trial. Probably won't get there until 2027 if I'm going to predict this, reading the tea leaves. But this could be an OJ type trial for us. Why? Well,
this very
because
well could be.
they're going to argue almost assuredly either insanity or diminished capacity. So you have to understand the rule in California is the M. Naughton rule. And this requires proving that a mental disease or defect prevented him from understanding the nature and quality of his act or knowing it was wrong. So he had such a defect that prevented him from knowing it was wrong. So they could argue that, hey, his substance abuse, etc., his mental state was such that he didn't even know what he was doing was wrong. He thought what he was doing was justified. He thought he was doing was right. Maybe he was hearing, whatever was going on, and his brain prevented him from knowing right and wrong. And they're going to need expert testimony for that. They're going to need him to be examined for that. So that's going to be a very, very serious defense they're going to need to go and take on there. Also, they might try to mitigate for the plea or sentencing based on mental health or substance abuse. So they may try to say, okay, look, because of his, poor mental health, because of his substance abuse, that's going to mitigate this down. That is very, very, very possible. And it's very possible that this could be a thing that does indeed happen. So if they do try a plea, I could see them taking a smaller plea just based on the prosecution having to gamble on this possible defense working, because it could theoretically work in the case of Nick Reiner given appropriate expert testimony. So I do think there is a chance of a plea on this, and I'm going to have to watch this and see how it develops and see what's filed by the defense. I want to know what you guys think in this case. Or do you want to follow it? Are you interested in this? Let me know in the comments below, and I will catch you on the next one.
I'm a little interested for sure. Yeah, no, that's a big one. That's honestly a big one. Your Honor, my client claims his parents were glowing, and he had to stop that glow. All right. So, on to the next one. Next one. Let me tell you what. We have posted 3 days ago. Yeah, 3 days ago. The fake UPS delivery that turned deadly. This is from Midwest Crime. So let us see what is going on here. Uh-oh. Oh, no.
Hey, come here, kid. Come here, buddy. Come here.
And there's fucking children involved. God damn it.
On January 26th, 2024, a family of 5, a father, a mother, their 20-year-old son, and 2 young children under the age of 5, were living a normal day inside their home on 94th Avenue Northwest in Coon Rapids, Minnesota, completely unaware of what was coming their way, as a navy blue Nissan Altima pulled up outside, and 3 suspects stepped out, 2 of them dressed in UPS-style uniforms, pretending to be delivery workers while secretly planning a robbery. A plan that would, within minutes, explode into a brutal encounter that would shock the entire community.
Our
coverage is brought to you by Morgan & Morgan. A crash,
Morgan
a fall,
Morgan.
a serious injury that changes everything. If it wasn't your fault, why should you settle for less? Insurance companies often push low offers, quick checks that barely cover the bills. But Morgan & Morgan knows what real justice looks like. They've helped recover billions for injury victims nationwide, including cases where
look, they have like 18
payouts were 30 or 40 times higher than what insurers offered. If you're injured because of someone else's...
Seen by the public before.
All right. I mean, thank God they have cameras.
Están tocando.
You don't even need to be qualified. You just need the name Morgan. Nerdy Texan, how's it going? Wait, they just walked away?
One of the victims
What
steps
kind of
out,
weirdness?
apparently completely unaware the delivery is a setup.
Oh, dude, someone's gonna get hurt.
Big dog. Ain't no big dog, is it? Ain't no big dog, is it? Not yet. Big dog. Hey, check it out. Come here. Don't move. Don't move.
Oh, shit.
Open the door. Move like that. Open the door.
Oh, no.
The home security
they got a
camera
whole
captures
crew.
the third suspect come up the driveway after he's waved in by the other men.
Come on.
Oh, no. Guys, you just need to do what they say.
She's right there. I'm not, I swear I'm not. I swear
Bro, what are you trying
Una
to do?
pistola, mijo. Tienen una pistola, mijo. Dos morenos. Mom. Yeah. Please, please, don't do anything,
Oh,
please.
come on.
The mother managed
You
to
guys
call
are
911, leaving the line open so dispatchers could hear what was happening
Nice,
as the
good
chaos
job.
unfolded.
Good job, Mom. Good job, Mom.
Emergency. Hello?
Oh my gosh. Give me the money. And I ain't playing. Look. I know. Hey, Mario.
There you go.
Come on with the money, man.
Naked. Okay. Ow.
Stop playing with me.
Ow.
Give me the money.
Okay.
I'm gonna smack out you.
I will give you whatever
Dude,
you
oh
Go
my
get your money
God.
then.
Okay, that's
Come on. You get when you move
Oh
too.
my God.
Get up.
I'm getting up.
I'm telling you, I'm gonna
Please.
smack out your son.
Oh, okay, I'm going.
Come on in.
What the hell?
All right, where the money? Go get it. Yeah. You ain't playing. Go get it.
It's right here.
Get it. Come on. Come on. Open it.
Jesus.
Don't move. Yeah, hurry up. No, just hold it. Sit down. If you move, open. Where is that? This ain't all the man. You finna play with it, so I see I gotta be violated.
No, please
Okay.
don't. Like, that's all the money we have.
This ain't nothing. This
That's all we have.
okay.
Ow.
All right.
Ow. It's all we have.
Jesus.
Oh my God, it's all we have. Oh my God.
Are you kidding me?
Oh my God, no. It's all we have. Oh my God.
With no mercy, one of the intruders turns on the father, 39-year-old Mario Alberto Trejo Estrada, and a single shot to the head ends his life in the entryway of the
Oh my
home.
God.
Where are my babies?
I have money for you.
Where are my babies? Where are my babies?
I have money for you.
Where are my babies?
Oh my gosh. Okay, move. Police, okay.
Just minutes later, officers arrive at the house after being dispatched to the 911 call placed by the mother, unaware of what they are about to walk into.
Police department!
Sir, I had to skip forward a bit.
I heard kids screaming in there. Police department! 1409, give us the channel for now. I got a male down on the ground. I got blood.
Grab it, police! Police department!
Hey, come here, kid. Come here, buddy. Yep. I think they're dead. Come here. There's another kid. Come here, buddy.
Come on, buddy. Come on.
Come here. There's another kid. Come here, buddy. So he's through the kitchen. Hey, buddy. I can see his diaper now. He's a little closer. No, he's pretty far in there. You see his diaper? See, on the ground. I can't see past it. Yep. Stay with the kid for now. We're gonna get you another kid here in a second. Hey, buddy, come here. Come here, bud. Come here, bud. Kyle, cover me. Hey, buddy, come here.
Come on, kid. There you go. There you go. Come on. There you go. There you go. There you go.
Come here. Come here. I need you to come with me.
We're trying to get the kid out.
Come here, bud. Come on, buddy. Come on, buddy. Come here. Come here.
I got candies. Come on.
Come here. Come here. It's okay.
Oh my God!
Okay.
You can't tempt him with candy.
Come here, kiddo. Come here, kiddo.
Come here. 1309. You've got 2 more cars coming to the area. 31.
All right. Okay. The kids are safe.
After
I don't
rescuing the
think
2
anybody
young
else is
children,
alive, though.
officers were faced with a horrifying scene. 3 victims, each killed by a gunshot wound to the
Yeah.
head. The house was immediately secured, and investigators began meticulously collecting evidence, including physical items and surveillance footage from cameras throughout the home, in an effort to identify the perpetrators. The navy blue Nissan Altima was traced to 39-year-old Alonzo Pierre Mingo, who was arrested later that day after being spotted leaving his Fridley residence. Further investigation, including home surveillance, DNA evidence, and cell phone records, led law enforcement to the 2 other suspects, brothers Omari Malik Shumpert and Demetrius Trenton Shumpert, both of whom were arrested shortly thereafter.
Good.
All the evidence, from security footage to forensic
they
and
got all
digital
3 of
data,
them.
pointed directly to the Shumpert brothers, who had tried to cover their faces, leading straight to the interrogations.
Do you know the incident I'm talking about?
No.
Okay. So you have no idea about...
I know that somebody got locked up.
Who got locked up?
Somebody is a name that you saying.
Who got locked up?
The name that you saying. You said Alonzo, somebody's name Alonzo or something like that.
Okay. And you know Alonzo?
Yeah, a little bit. I know of him.
Okay. You knew more of just of him, right? You guys go way back.
No.
To Chicago.
I'll say yeah.
Dude, they know all about you right now.
Somewhat of the same level of respect, right?
Yeah, but
we do our
like you saying way back, like basically like friends, anything like that? No.
Not
They're
friends.
all for just money.
All right, but you've known him all the way back to Chicago, right?
Yeah.
Okay. Where are you living now?
Huh?
Where are you living now?
Alone in Minneapolis.
When's the last time you talked with Alonzo?
I'm gonna say like a month ago or something like that.
A month ago?
Like a month and a half, I think.
A month and a half ago?
Yeah.
Okay. That's a lie. So that was already on camera. That was already put on the news. It already showed Alonzo shooting a person. Okay? I don't know if I explained it well to you or not, but the more information I tell you, the less you can tell me to help.
No, but I was saying you can't tell me about that because I heard about it. The whole world know about it.
Sure.
That's everywhere you go. Hey, you heard about what happened? Somebody got killed in Coon Rapids. 4 or 5 people.
In
how
what
many more people
rapids?
got killed? I don't know.
Okay.
So what did I do?
You were there.
Wasn't.
Yeah, you were.
Wasn't there.
You were.
You were. We have you on video, dude.
You're probably not going to take my word for it or anything, but I'm not lying to you. I'm not making stuff up. We had the pull camera. Well, we didn't. Somebody had a pull camera in the house. When we see you pull up, we see the 3 of you get out, walk up to the house. It's just you and Alonzo. He knocks on the door. They don't come to the door at first, and you start walking away. As you guys are partway down the street, or partway down the driveway,
Oh, nice.
he comes outside.
He's fucking explaining the exact how everything fucking went down. Yeah, nah, man. We got your fucking number. We absolutely have your fucking
So you
number.
guys walk back. Okay? On the door there was a camera. And you had gloves on, you had a mask on, but we're still able to tell it's you.
Yeah.
With a mask on.
Yeah.
Another mask on. Oh,
Okay.
absolutely.
And then, who'd you wave up?
I didn't wave nobody.
You're sitting in the car and you waved them up.
You said I was sitting in the car?
No, he was sitting in the car.
No, he was sitting in the car. Come on, man.
You waved him up.
I don't know.
Okay.
I don't know who that was. I don't know who that was with no mask on, but it showed it wasn't me. You didn't ask me where was I at, or was I somewhere else, or nothing.
No, we're not asking you that. We're telling you this is where you were.
Where were you? And then I'll follow up on that. And
you know I was there already, right? That what you said?
I do.
Oh yeah, big time.
If you're saying you're somewhere else, you tell me where you were, who you talked to, and I'll follow up with them and rule you out. That's only fair, right?
That's crazy. You say on the 13th?
The 26th. January 26th.
I know I wasn't there. I wasn't at nobody else. I wasn't at nobody's house.
Okay. We go in a crime scene, the whole 9 yards. You're touching your face. You're hitting the liver.
I see?
Yeah, I'll grab them.
You said I'm hitting what?
You're touching your face. You got a mask on. Yeah. You're touching your face. You're touching the lizard cage. You're touching the face. You're touching different areas. You're breathing through the mask. Okay? We're getting to the point of the evidence is mounting up so high, it's hard to get out. Okay?
Yeah, you touched everything, dude.
There's also audio, and you can be heard on there.
There's audio and visual.
Ain't no big dog, is it?
What?
Ain't no big
Ain't
dog,
no big dog, is it?
What do that mean?
Ain't no big dog.
Yeah, you tell me.
You tell me. Can you say that?
What would I say?
Tell me.
What do that mean?
That's what you said when you were there. You also have a
They got him dead to rights.
I don't say nothing like that. I don't know what that means. What do that mean?
I'm not sure.
Oh, that's just what you said
I'm
when
not
you
sure
were
what
walking up and you were
state
talking
Why would
to,
you want me to say it?
to the guy in the
Minnesota.
driveway.
Okay, it's in
Why would you
Minnesota.
want me to say
So that I can compare it to what I heard on the video. Right?
it? I'm not gonna say nothing.
Okay. I'm just saying...
You saying you knew I was there already, so why you want me to say it?
Well,
anything.
I can say that you're there all day. And I can prove that you're there, and I can prove what happened because...
You can prove I was there? Sure.
Yeah.
Oh,
because
God,
everything
yeah.
is on video, man.
26. Yeah, the 26th. That's the 26th. That's the day I couldn't go to work because I had my baby with me.
Okay.
And my baby mama, she wasn't trying to come get him. And I didn't go to work on that day.
Okay. Where were you?
I was in the house.
Is that what you're gonna go with? That's what you're gonna stick with? You were never at the house?
You were in the house. Yeah, dude, you don't have no
The
alibi.
photos that you got?
Yeah, I can get you still
Nobody can
photos of it.
confirm where you were, man.
Doing good? You still want me to get warm water or cold water?
Man, you need a soda at this point because you're going to jail.
You can grab it. You can hold it if you want.
I don't hold it.
You don't need to?
And that supposed to be me? Or somebody else?
I know it's you. I can print off a couple more, but I don't know if that's going to convince you or not. But just so you know, I'm not lying to you.
I know you ain't lying.
On any of this. Okay?
All three suspects in the Coon Rapids triple homicide were indicted on multiple counts of first-degree murder, upgrading their initial charges of second-degree murder. Alonzo Pierre Mingo, identified as the alleged gunman, was found guilty by a jury on multiple counts, including 4 counts of first-degree murder. In September 2025, Mingo was sentenced to life in prison without the possibility of parole. Demetrius Trenton Schumpert, who participated as an accomplice in the robbery, was indicted on 6 counts of first-degree murder.
Holy shit.
Prosecutors sought an aggravated sentence against him, citing the particularly cruel treatment of the victims, the involvement of 3 or more active participants, and the fact that the crime occurred in the presence of 2 minor children. On November 20th, 2025, Demetrius Schumpert was found guilty on all counts of first-degree murder and faces the same mandatory life sentence without the possibility of parole when he is sentenced in January of 2026. The third co-defendant, Omari Malik Schumpert, was convicted in December 2025 on 5 counts of first-degree murder, 3 counts of second-degree murder, and 2 counts of aggravated robbery. He is also scheduled to be sentenced in January 2026.
Good. Honestly, good. Though, again, I don't know. I feel like the death penalty should be only saved for the worst of the worst, and I feel like that was the worst of the worst. I mean, that was amongst, like, yeah, they weren't bad enough to kill children, but they were so bad enough to kill the parents of said children and the dog and whoever else was there in front of the children and leave those kids fucking traumatized. Yeah, no, Rohime, no worries, I understand. We're gonna just wind down a bit. We're gonna wind down a bit with some court camera stuff. This says delusional witness thinks he can outsmart the defense attorney. This is from Audit, the court posted 5 days ago. Let's check it out.
On February 15, 2017, Oakland County deputies executed a search warrant at the Oakland Township, Michigan home of Joseph Sheely, a tenured business professor at Oakland University, after anonymous tips alleged that he was hosting parties for students involving drug use and underage drinking. 4 young adults were present during the search, including an individual named Jacob Spencer, and officers recovered ketamine along with 2 rifles and 1 shotgun, all unloaded. Mr. Sheely was charged on February 17, 2017 with 7 criminal counts, including
Michigan. You need to fucking simmer down. What the fuck? Guys, are you hearing this? I mean, Jesus Christ.
1 count of possession of ketamine, 1 count of maintaining a drug house, 3 counts of possession of a firearm in the commission of a felony, and 2 counts of delivery of ketamine.
I thought we were. I honestly thought we were going to, oh my god. I honestly thought we were going to wind down. From that, I mean, we still are. Kind of. But has he not really, like, Jesus Christ. I can't even believe this right now. Oh my god. Okay, let's continue.
One of which stemmed from allegations that Mr. Sheely provided ketamine to Mr. Spencer. Mr. Sheely's case went to trial in January of 2018, with Oakland County Circuit Judge Cheryl Matthews presiding, and Mr. Spencer was called as a witness for the prosecution. Mr. Spencer was granted so-called use immunity, which protects a witness from having their own testimony used against them in a criminal prosecution, allowing them to testify about potentially incriminating conduct without risking charges based solely on what they say on the stand. During the trial, after Mr. Spencer answered questions from the prosecutor on direct examination, Mr. Sheely's attorney, Neil Rockind, had the opportunity to cross-examine him.
Mr. Spencer, you have been around people who have used narcotics, haven't you?
Yes.
And you've seen people who...
for those who don't know, real quick. And yes, sorry, Naruhime, you're gonna get a little, you're gonna get a little shout out here. This is actually a viewer submission for the video submissions in our Discord channel. And this was posted a little bit ago by Naruhime. So congratulations, and to say everyone thank you for us even watching this, because if not for them, we would not be.
In your experience appear to be high, haven't you?
Yes.
Who appear to be under the influence of some kind of a drug or affected by some kind of a narcotic, haven't you?
Yes.
Can you look the jury in the eye and tell me whether or not you've taken any narcotics today? Prescription pills, anything of that sort? Xanax, opiates?
Yes, I have taken prescription pills today. I've taken...
When did you last take a prescription pill today?
This morning.
What time?
I'd say around 9 o'clock.
And what medication did you take this morning around 9 o'clock before you came to court?
I took Vyvanse.
Vyvanse. Vyvanse is an amphetamine?
Yes, I'm prescribed.
Vyvanse is for ADHD?
Yes.
The behavior, the way that you're communicating, and I'm going to speak to you, try to speak softly and have a dialogue with you, okay?
Okay.
The way that you're communicating now, isn't this the way that you've seen people communicate in your own personal life who appear to be high or under the influence?
Judge, I'm going to object to that.
What's the...
Judge, he can ask him if he's high or under the influence, but
I'm not to ask
he's
him.
asking him to evaluate his...
I don't understand the question.
Okay.
I don't understand how I could look at myself from a third-person view.
So well, first of all, so the prosecutor objected, Your Honor.
Say your question again. I didn't understand.
Yeah, sure. The way that you're communicating now, I mean, can you hear, I'll withdraw and I'll ask it differently. Can you?
Right now?
No, I'm not.
Okay.
This is the way that you normally communicate?
I don't normally communicate from a stand in circuit court in a case involving an older man that threw parties with underage people providing drugs. I'm nervous. If you're accusing me of being drugs, then you're doing a very bad job as an attorney.
Okay.
You should be asking questions that are actually going to help your client.
Okay, next question.
I appreciate that.
And now I'm angry, and I'm going to tremble my voice even more, not because I'm on drugs, but because I'm nervous. And you're intimidating. That's what you do.
Okay,
and it's not going to work.
Okay,
calm down, calm down.
The questions and then
That's my answer.
Okay, we'll just answer his questions and we'll get you out of here, okay? All right, go ahead, Mr. Reiner.
Thank you, Your Honor.
Look at that. He's mean dogging.
Today, you testified a few moments ago to the jury in response to Ms. Hand's questions that Joe has provided you with ketamine on prior occasions at his house.
Correct.
And you said it was almost, I think I wrote down, said almost every time you were there. You remember that?
Yes.
At the preliminary examination, that was when you testified before in district court. You remember that?
Yes.
And you took an oath at that time, is that right?
Yes.
An oath.
And at the time that was closer in time to the events of February 15th, true?
Yes.
And you told that time you were asked this question, and this was your answer on page 62. Approximately how many times had you ingested ketamine that the defendant gave you at his house? Your answer, it was one time. It was that night. Wasn't that your answer under oath at the preliminary examination?
Yes, it was.
Today you've told the jury something different, haven't you?
Yes, I have.
So, 2 times under oath, you've given 2 different answers.
Ayo.
True?
True.
Both of those pieces of testimony can't be true, right?
Mr. Rockkind, quote-unquote, impeaches Mr. Spencer by pointing out the conflict between his earlier testimony during trial that he received ketamine
after that, look, all I'm saying is after you said that you have given this jury conflicting testimony, after he confirmed and said yes, I'm like, are you aware of what the term perjury means? Look. She is very interested in these answers. Hold on. Let me get my there. Oh, darn it! Hold on. Look, she is very interested.
multiple times.
Stop it. There, see right there. Look at that. Look at those eyes. She's like, well, what you got to say? What you got to say about that?
And his sworn preliminary examination testimony that he had been given ketamine only once. Impeachment is the process of challenging a witness's credibility, which can be accomplished by showing that their story has changed over time. Under Michigan Rule of Evidence 801D1A, a witness's prior statement is not treated as inadmissible hearsay when 2 conditions are met. First, the witness must be testifying at a current proceeding and subject to cross-examination. And second, the earlier statement must have been inconsistent with what the witness is saying now and must have been made under penalty of perjury, such as during a preliminary examination. When these requirements are satisfied, the prior sworn testimony may be used to demonstrate that the witness is contradicting themselves. Now, because Mr. Spencer previously testified under oath that he was given ketamine only once, Mr. Rockkind was permitted to confront him with that statement to show the inconsistency and undermine his credibility before the jury. Before we continue today's episode, I want to give a big thanks to the sponsor of this episode, Incogni. If you're anything like me, you've probably searched your own name online and been surprised at how much of your personal information is floating around. Your address, phone number, even your relatives' names, it's all out there. And that's exactly how scammers get a head start. Identity theft, loan fraud, stalking, all of it starts with exposed personal data. That's where today's sponsor, Incogni, comes in. They go beyond just removing you from data brokers. They help you disappear from the internet entirely. Incogni automatically tracks down and deletes your personal information from hundreds of sites, including people's search databases, business directories, and other private sources. And if you find your data somewhere specific, their custom removals feature lets you send in the link directly so a privacy expert can handle the takedown for you. I've seen firsthand how easy it is for scammers to use leaked information. One exposed record can lead to an endless amount of credit fraud, impersonation, or harassment. Incogni gives you a way to fight back. You approve it once, and they take care of the rest, sending verified removal requests and following up until the data is gone. Right now, Incogni is offering members of the ATC community a 60% discount on your plan when you visit incogni.com/court and use code COURT. So if you want to protect yourself and your family from scams and identity theft, click on the link in the description to
how to do this. Okay. And then I need to actually send this to somebody. I legitimately need to send this to somebody. Hold on. Hold on. Alright.
get started protecting your data today. Thanks again to Incogni for sponsoring today's episode.
I know you said to only keep this yes and no, but I'd like to explain that this isn't about the...
I really need a, I need either like a facepalm asset or like pinching the bridge of my nose. Because I literally, like, as soon as, like, I know you said yes or no, but I'd like to explain. I paused it because, dear God, no, you don't get to, if it's yes or no, it's yes or no. You don't get to expand. God damn it.
The amount of times that I did ketamine at Joe's house, this is about, it goes beyond that. Like I've stated
Kiss
multiple
Trail is brought to you by Raid Shadow Legends.
times.
As the guy gets guilty, we'll give 50% off to our first pack.
I was very inebriated every time that I was at his house. I may have even been given ketamine without knowing it.
You've never told the police before in response to the question. Let me finish my question.
Look.
You'll get every opportunity, Mr. Spencer. I'm keeping my voice very calm. I'm going to give you every opportunity to talk as much as you'd like. But you've never before today in front of this jury made an allegation that somebody gave you ketamine without your knowledge. Isn't that true?
Can you please rephrase the question?
Yes. Until just now, you've never told the police or accused in a formal setting in this case, Joe, of having given you ketamine without your knowledge, right?
Correct.
That's something new that you just told the jury now.
Well, maybe it was something that I didn't consider when I first stated that I only did it one time.
I'm sorry. I'm asking you, I'm moving on to another subject.
Yeah, let me
You're here testifying in court. You understand that, correct?
Mm-hmm.
Yes?
Yes.
You've just made another allegation against Mr. Shield that he drugged you with ketamine without your knowledge.
He drugged you, with ketamine without your knowledge. I'm gonna just, we're just gonna go, just a little bit. 1.25. Fine.
Isn't that true? That's what you just told the jury?
Yes, it is.
Never told that to any police officer formally, nor did you testify to that previously in this case?
I may have mentioned it before. I'm not sure. There were so many times that I talked to detectives.
You just told the jury a second ago that it didn't dawn on you to think about that. Now you're saying that you actually may have said something about that. Those are two different things, aren't they?
Do you want me to go back and explain myself?
No, I'm asking you a specific question, Mr. Spencer.
Yes.
So, your testimony today includes a new allegation against Mr. Shield that you were somehow drugged without your knowledge.
I'm not saying that. I'm saying that it's a possibility. I'm not saying that that specifically happened. I'm saying it's a possibility, as in there's no way anybody's ever going to be able to know that. I don't even know that myself. I'm just saying possibly, and maybe I considered that when I just said that I took ketamine multiple times at his house. Maybe I considered that it's a possibility, but there's no way I'm ever going to know if it actually happened. That's what I'm implying. I'm not alleging him of anything.
under oath, the prosecutor asked you on direct examination whether Mr. whether it provided you with ketamine prior to, at the time she went to his house. She asked you that. It was a very simple question. Do you remember it? Do you remember the question and answer a few moments ago?
Yes.
And you said yes. And you said, almost every time I was there.
Yes.
And you're saying that when you told the jury that under oath that you were thinking to yourself that maybe it was given to me without my knowledge? Is that your explanation for that testimony under oath?
Yes, it is.
Does that make any sense to you? That you would answer a question directly that he gave you drugs in the past, gave you ketamine in the past, but now when I'm questioning you, it's, well, maybe I was thinking of, maybe I was drugged and didn't know it, that's why I answered it that way. Is that really the explanation you want the jury to accept?
I don't know how else you would want me to explain this. I would appreciate if you could move on to the next question.
I'm sorry? You want me to move on to the next question?
Yes.
The questions I'm asking are, Mr. Spencer, pointing out from contradictions in your testimony. Do you understand that? So I appreciate you'd like me to move on, but I'm sure you can appreciate that the judge will ultimately...
Guys, I will give you money to anyone who in the next like argument they have with anybody, if they just go, I'd appreciate it if you move on to the next question. I swear to God, I'll give you $5.
Tell me when I have to move on. You understand that too, right?
Correct.
Okay. You want me to move on because it makes you uncomfortable to have to getting caught in what is untruthful testimony.
Well, there's a lot of these really small discrepancies, like how many times did you do this? How many times did blah, 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 that like, I didn't just like, this isn't like a test that I studied for. This isn't college. This isn't something that I think is like a huge deal. So when you guys throw all these questions at me and then throw it on the record, it's not something that's like constantly running through my mind every day. And I'm remembering all these little tiny details and splitting hairs about
kind
it.
of important.
That's what I'm doing? You think I'm splitting hairs? I'm questioning you about the truthfulness of your testimony and contradictions, and you're telling the jury that that's splitting hairs. Is that what you're characterizing?
I'm giving my time trying to answer all of these questions to the best of my ability.
We'll get to the reasons why you're here later, okay? Do you understand? But I'm still going to put these questions to you. Is that okay with you, Mr. Spencer?
Yes.
Say, Eljo, this is the defense attorney. He's cross-examining. He's only allowed to ask leading questions. He's only allowed to ask leading questions, yes or no questions.
Thank you. You testified today that on February 15th that you drank alcohol. That's what your testimony was under oath just a few moments ago to the jury, right?
Correct.
You were asked this question at the preliminary examination, page 62, lines 18 to 19. Did you drink alcohol that night? Your answer was no, I did not. Correct?
Correct.
Oh my God.
Again, your testimony today is different than it was at the preliminary examination when you testified under oath there, right?
Correct.
You told the jury a few moments ago in response to Ms. Hand's questions that...
Look, the whole point of cross-examination is to basically challenge the credibility of the witness in the eyes of the jury. In light of the fact that that's what cross-examination is. This man is doing an excellent job.
She asked you about nitrous oxide. Remember those?
Yes.
She asked you about whether or not you asked you about cocaine being provided to you at Joe's house. Do you remember that?
Yes.
You said that Joe had provided you with cocaine. Again, you said that that was your testimony on direct examination. Do you remember that?
Yes.
That's not true, is it?
Pardon me?
Joe never gave you cocaine. You didn't do cocaine at Joe's house. That's a lie, right?
Please, can you please rephrase the question?
The question was confusing to you?
No, can you just...
Yes. You testified today that Joe gave you cocaine and you used cocaine at Joe's house previously. That's what you testified to today. You've acknowledged that. I'm putting to you that that is not true. That is a lie, correct?
That is not a lie. I did use cocaine at Joe's house.
Okay. On page 61, lines 15 through 17, at the preliminary examination where you testified closer in time, the question was, did you partake of the nitrous oxide or the cocaine? Your answer was no, but I've heard and seen it at his house on occasions. Wasn't that your answer under oath then?
That may have been. I don't know. I haven't...
Both of those can't be true, Mr. Spencer.
Yeah.
Okay, so that was your answer at the preliminary exam, correct?
Yes.
Okay, that's the next question.
Both of those can't be true. What you testified to today to the jury and what you testified to under oath at the preliminary examination, right?
Yes.
So one of them is a lie.
I was lying about not using them.
You were
Because I
lying
felt
at the preliminary
guilty-
examination.
I felt guilty because my dad was in the room.
At the preliminary examination, you were under, let's just, so the jury understands that. You took an oath before you testified in the preliminary examination. Is that correct?
Oh,
I didn't want my dad to hear that I was using
perjury.
cocaine.
You took an oath to testify to the truth at the preliminary examination in district court, right?
Correct.
You raised your right hand just as you did today.
Correct.
You looked, there was a judge there named Judge Nancy Carniak, right?
Correct.
You looked her right in the
You're in
eye
trouble.
and answered the question, no. Isn't that true? And you're testifying now is that was a deliberate, intentional lie.
He said yes.
Isn't that perjury?
Well, he
Yes,
said-
it is.
There
Okay,
it
I'll
is.
rephrase it. You recognize that when you're under oath, you face the penalty of perjury, don't you?
Yes.
You understand deliberately and intentionally lying under oath for any reason is perjury. You understand that?
Yes, I do.
So you concede that you committed perjury from your own perspective. By your own words, you committed perjury at the preliminary examination.
Yes.
Mr. Rockhind impeaches Mr. Spencer with an additional inconsistent statement
Pretty
from the
good.
preliminary examination regarding his cocaine use. And when Mr. Spencer admits that he lied during that earlier proceeding, Mr. Rockhind argues that his conduct constitutes perjury. Under Section 750.423 of the Michigan compiled laws, it is a felony offense to, quote-unquote, willfully swear falsely about any matter while under oath. By acknowledging that he lied during the preliminary examination, Mr. Spencer effectively admitted to conduct that falls within the statute's definition. He was under oath, and he knowingly made a false
big time.
statement. However, even though Mr. Spencer's actions seem to satisfy the statutory elements of perjury, he would likely not be prosecuted because he testified at trial under a grant of use immunity. As discussed earlier in this episode, use immunity prevents the state from using a witness's own testimony as the basis for charging them with a crime. Therefore, while Mr. Spencer's admission allowed the defense to portray him as an unreliable witness, the immunity agreement would likely shield him from any perjury liability arising from that inconsistency.
When the police entered the house that night, you were in possession of drugs, right?
Yes, I was.
And tell us again what drugs you were in possession of.
Xanax.
Xanax. How many Xanax pills were you in possession of?
2.
And you did not have a prescription for those pills, isn't that true?
That's true.
You understood at the time you were possessing them that it was a crime to possess them, isn't that right?
Yes, I did understand that.
You understood that it was a serious crime,
Yes.
and you understood that it was a felony.
Yes, I did understand that.
So you knew that when the police entered into the house that night that you were committing a felony.
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge Acosta, legal conclusion.
I would try
That's
it.
true.
I would try it. It's fine. I would try it. I'm asking questions very politely, Your Honor.
He is asking questions.
But you know that's not true.
Well, I don't know. I
Okay.
resent that
Downhill.
because I'm not suggesting that I know that that's not true, and I don't like to suggest. You know me. I'm not suggesting anything.
You suggested to the jury that if you have 2...
I'm asking a question. You know what? Then I'm asking a question, and if I'm wrong about that, then I'm wrong about that, and I certainly will withdraw that.
All right,
So,
next question.
so I will withdraw that.
Mr. Rockhind
was a
asks
little
Mr. Spencer
screwed
whether
up.
he knew that he was committing 2 separate felonies by possessing 2 Xanax pills, prompting an objection from the prosecutor, and Judge Matthews sustains the objection, explaining that Mr. Rockhind's question incorrectly suggested to the jury that a person can be charged with 2 counts of possession merely for having 2 pills. Alprazolam, the active ingredient in Xanax, is classified as a Schedule 4 controlled substance. An unlawful possession is governed by Section 333.7403 of the Michigan compiled laws, which makes it a felony to knowingly or intentionally possess a Schedule 4 substance without a valid prescription. The statute criminalizes the act of possession, not the number of units possessed. Thus, possessing 2 Xanax tablets at the same time constitutes a single offense of possession rather than 2 separate felonies. Accordingly, Judge Matthews sustained the objection because Mr. Rockhind's question implied to the jury that a person could be charged with multiple felony counts for possessing multiple pills of the same substance at the same moment, which is not an accurate statement of Michigan law.
And when you agreed to testify at the preliminary examination, it was your belief that if you cooperated and testified that you weren't going to be charged in the case. Isn't that true?
Yes, that's true.
And despite whatever it is that you did, you believed at that time that you'll end up with no criminal prosecution and no criminal record. Isn't that true?
That's what I was told.
And who told you that?
That.
Ms. Hand, seated to my right and to your left. And despite whatever it is that you did, you'll end up with no criminal prosecution and no criminal record. That's what you're testifying to. That's what you just testified
granted
to.
Use immunity, I believe the term is.
And you just testified a moment ago that you were told that you'd end up with no criminal prosecution and no criminal record, right?
Well, no prosecution for the possession of prescription pills.
So that's more than use immunity. Use immunity means, doesn't it, as far as you know, that you just get to, your words can't be used against you. But you're telling us that you actually have an understanding that you're not going to be prosecuted at all for your felonies. right?
Correct.
Isn't that in part why you're in here saying the things you are about Joe, so that you avoid a felony prosecution and felony conviction yourself?
Correct.
You're a young person.
Let the defense attorney, whether or not you agree with him or not, he's actually doing kind of an amazing job right now.
You're 20 years old, you said? Yes?
Yes.
You want to have a career in the future, right?
Yes.
You have a lot to lose. Would you agree with that?
Yes.
And your participation or involvement in some kind of crime could interfere with that. Would you agree with that?
Yes.
You understood that based upon what you were being told, that if you talked about Joe, you'd be able to avoid being in trouble, right?
Yes.
1 year ago, well, so not 1 year ago, this was back in February 15th of 2017 is when this search of Joe's house took place, correct?
Correct.
And today is January 18th or 19th. 19th, Your Honor? 19th. Thank you. In that time, you have not been charged, have you?
No, I have not.
And there are things that you have, you did go down and talk to the police on March 1st of last year, correct?
Yeah, it was around that time.
You got a record deal the day before that, didn't you?
Pardon me?
Didn't you get a record deal? Did you get a...
That makes it sound like he's a singer.
No. Well, aren't you a performer, a DJ?
What does this have to do with...
Well, we'll let the jury sort that out.
Are you talking about this case?
Yes, I am. Yes, February 28th of 2017, the day before you went down to the police department to talk about Joe, didn't you get a record deal?
Oh, you do mean like singing?
I think a DJ.
Oh, I thought you meant, okay, all right.
Didn't you get a record deal? Didn't you just get a contract by a company that signed you? Didn't you?
Objective relevance?
Something you were proud of.
I'm confused as to why you're asking me this and why you're asking me to disclose personal information.
He's trying to ask you if you have a lot to lose.
So on February 28th, before you went, you talked to the police. You got a record deal. You got a professional music contract. That was something you coveted, that you were proud of.
Yeah.
You understood that a criminal case and a criminal prosecution could interfere with that, didn't you?
Yes.
So the very next day, March 1st, that's when you went down and you talked to the police at the police station about Joe, right?
Yes.
Okay.
On January 24th, 2018, following a multi-day trial, Mr. Shealy was convicted on 3 counts: possession of ketamine, maintaining a drug house, and possession of a firearm while maintaining a drug house. The remaining charges from the original 7-count complaint were not sustained at trial, including the charge for delivering ketamine to Mr. Spencer. On March 5th, 2018, Judge Matthews sentenced Mr. Shealy to a total term of 3 to 4 years in prison. After completing his incarceration, Mr. Shealy was to be deported to Canada, his country of citizenship. This episode illustrates just how heavily a case can turn on the credibility of a witness and the lengths to which the defense may go in order to challenge that credibility. Over the course of cross-examination, Mr. Rockine walked the jury through multiple inconsistencies in Mr. Spencer's statements, from his conflicting accounts of how many times he had allegedly received ketamine, to his admitted dishonesty about cocaine use, and even his initial intent to deceive the police about his own possession of Xanax. By highlighting these contradictions and emphasizing that Mr. Spencer only began cooperating once assured that he would not face charges himself, the defense sought to show that his testimony was shaped not by truth, but by self-interest. Ultimately, the jury acquitted Mr. Shealy of the delivery charges, including the count tied specifically to Mr. Spencer's allegations, while convicting him of possession of ketamine, maintaining a drug house, and possessing a firearm during the commission of that offense. This outcome seems to reflect the jury's assessment of Mr. Spencer's credibility, formed in part by Mr. Rockine's effective, albeit imperfect, cross-examination. Now, let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that...
Pretty good, pretty good. And there we go. There we have it, chat. Thank you so much for spending the last couple hours reacting to content with me. Don't forget to like, comment, subscribe, hit that notification bell as hard as you possibly can. And we will, of course, see you on the next one. And let me just figure out who we're gonna raid out into. Stream settings. Edit. Customization. A redirect. Oko is live. Let us raid out into Oko. Oh, right. And then I'll do this for you, too. And bam. Oh, thank you. The deal? Yeah, we'll do this one. Okay, guys, go, because it's the end of the stream. Enjoy this cover.